The Supreme Court has reserved judgment in a consolidated suit by Kogi State and other state governments against the legitimacy of the Economic and Financial Crimes Commission, EFCC, and other anti-corruption agencies. The Apex Court made this position after hearing the submissions of the parties in the suit. Arise correspondent Godfrey Eshemoge has more.
Tuesday's proceedings began with Kogi and 18 other states asking the Supreme Court to declare that the EFCC and other anti-corruption agencies are not legally constituted and should be scrapped. The number soon dropped to 16 after the names of the Attorneys General of Adamawa, Anambra and Ebonyi states were struck out by the 7-member panel of the Supreme Court after they applied to withdraw from the suit. In his submission, Attorney General of Kogi State, Abdulwahab Mohammed, said the EFCC is a product of the UN Convention. According to a former Attorney General, Kanu Agabi, who midwifed the bill that birthed the EFCC and others. The Attorney General of Kogi State said Section 12 of the Nigerian Constitution spells out the mode of adoption of international treaties, which in his view was not adopted during the establishment of the EFCC. In that light, the anti-graft agency, he adds, was not well-founded. Mohammed noted that the UN Convention Against Corruption wasn't meant to be applied, but to stop the illicit movement of funds out of the country. He then prayed that the Apex Court grants his prayers and for costs to be awarded in favor of Kogi and other states against the federal government. In a counter-argument, the Attorney General of the Federation, Lateef Fagbemi, said the National Assembly didn't domesticate the UN Convention Against Corruption, adding that in this case, the government is relying on Section 15, subsection 5 of the Constitution and not Section 12. Fagbemi says the section of the Constitution gives the government's fight against corruption the required legitimacy. Nasarawa is one of the 16 states in the suit still challenging the legality of the EFCC.
Our own case is challenging the constitutionality of the directive issued by the NFIU, limiting cash withdrawal for states, knowing fully well that in Nasarawa State we have a social investment policy geared towards enhancing the living standard of the people at the grassroots, where His Excellency the Governor Engineer Abdullahi A. Sule, out of his passion for lifting people out of poverty, initiated a program through which indigent people at the grassroots level are being shared some stipends running into millions of naira, and is a talk of the states. And the entire people of the state are very happy with that. Now, by the time this policy comes on board to stop, limits the cash withdrawal by the states, it will frustrate this program, and it by extension affects the living standard of the people at the grassroots.
The Justice Uwani Abba-Aji-led Apex Court panel will communicate the date to decide the fate of the EFCC and other anti-corruption agencies. Godfrey Eshemoge, Arise News.
Joining us now on the show as we review the state in Nigeria versus EFCC's Jiti Ogunye, a lawyer. Good morning and most welcome to the morning show.
Yes, my pleasure. Thanks for inviting me.
Jiti, we've been expecting you since Monday. It's good to have you here finally.
Yeah, thanks so
much. 3 of the states, Nasarawa, Ogun, and Cross River, they are challenging the NFIU and raising issues about, autonomy, financial autonomy for local councils. All the 16 that are in the case now are challenging the legality of the EFCC, Kotunu BK versus Federal Republic of Nigeria, and Section 12 is their reference on which they have based their case. The AGF, Attorney General of the Federation, is saying, no, Section 12 is not the main reference, it's Section 15, under which the Nigerian government has powers to address issues of corruption. Now, the Supreme Court will decide that. I don't know whether you want to comment on the Supreme Court, what it will do when it gives its final ruling on the matter. But 2 other, persons have intervened. Agbakuba, SAN, Femi Falana, SAN. They seem to have a meeting point that there is need to constitutionalize the EFCC and the other agencies, and that perhaps we should not throw the baby away with the bathwater. Just by way of quick summary, but what's your view on this matter?
Thanks for inviting me. You know that we cannot comment on what is going on at the Supreme Court in a way that suggests that we are forecasting or predicting the outcome of that adjudication. We're caught by the sub-judicial rule. However, as you know, the fair comment principle allows media with a public interest matter to discuss the matter. Now, my view is that the parties that have gone to the Supreme Court to raise this important issue has a right to approach the Supreme Court. Individuals have right of access to the court, Section 6b. So if individuals can exercise their rights, why won't state parties or government of states be enabled by the provision of the Constitution to approach the Supreme Court for a determination under Section 232 of the Constitution, being the original jurisdiction provision in the Constitution. And so, upfront, I state that the assumption that is usually drawn that, states, for going to the Supreme Court at all, want to destroy the anti-corruption agencies, that assumption is not very correct, if you ask me. It is the business of the court to adjudicate. Parties have a right to go. You see that when the Independent Corrupt Practices and Other Related Offences Commission Act was enacted in 2000, the Ondo state government went to court. Indeed, in that case, the Ondo state government went to court in the middle of the problem they had with the ICPC. If you recall, the Commissioner for Finance and the Attorney General of the state were embroiled in that matter, Chief Ogedengbe and Chief Ojo. And so they went to the Supreme Court, and they hired Chief Rotimi Williams on that occasion. And the Supreme Court looked at the matter and decided it. Indeed, they invited some Amici Kure, Professor Ben Wabeze's son, Olisa Bakova, son, and Chief Afepaola, son, were Amici Kure in that case. And so there was very robust, and the Supreme Court decided the matter the way it decided the matter to save the act. Indeed, the Supreme Court founded its decision on the provision of Section 15(5), and all the other arguments will not matter because the Supreme Court, led by Honorable Justice Uwais, who was the CJN then, he presided and he read the leading judgment. The way they interpreted the matter was that corruption was a major problem for Nigeria, and so a central or a national body to deal specifically with that issue was proper, and it was not anti-federalism. So it was therefore good that, although there is a background to this, since the emergence of this EFCC in 2004, at every turn and bend, people have come forward to look at the EFCC and say that there's a problem with it. Indeed, only recently, the Attorney General of the Federation, while he was being confirmed, stated on the floor of the Senate that he was committed to reform, and that for EFCC, for example, the combination of prosecution and investigation powers, was odd, and that it would be more, convenient for him to look for a split of those roles. And this has come over and over again, whether the EFCC was observing the rule of law and so on and so forth. So the point I'm making is that the challenge to the existence of the EFCC should not just lead us to conclude that, the EFCC is going to go under. The people have the right to challenge the EFCC if they want to challenge its existence. Yeah.
All right, okay. In Mr. Falano's submission, he had said that, on different points, cited a number of cases, the Supreme Court had affirmed the legality of the EFCC, upheld the legality of the EFCC. I don't know to what extent that would affect this case. But my question to you would be then, in the event that it's ruled that it's not a legal entity, or it has to be constitutionalized in the event. I know, just being... Okay, all right. But I just wanted to ask, but there was a question that was raised around, would it nullify the activities of the EFCC so far, the convictions they've had and what they've done, the activities so far?
It will not, in my view. And that kind of hypothetical situation or scenario can be painted. The only thing is that we can't discuss the merits of the case. And so, if the Supreme Court, because once the matter comes to court, the matter could go either way. Yeah. You can't usurp that power from a court of law and say that it must only rule in one direction. And so, if that were to happen, the sun will set today, or on that day that happens, and the sun will rise the following day. So Nigeria will not collapse. So we'll take the pieces and then see what we're going to do with it. But, I'm familiar with all the cases that have been decided on the matter, a number of them. There's indeed Olabisoye and FRN. There are also a number of cases, Shema and FRN. Yes, then there's Olagunju and FRN. There is Daudu and FRN, which deals with the power of the FCC. And very important, indeed, Daudu and FRN alter the burden of proof in the law of evidence, that in interpreting Section 19.3 of the Anti-Money Laundering Act, that the presumption or the burden of proof, which never shifts in criminal cases, which rests on the prosecution, will have to shift, because the Supreme Court looked at it and said, look, if you have some humongous money in your account and you are not able to explain how the accretion has come about, an anti-corruption agency is not a magician or spirit that will know how you got that money. You are the one to explain. And that in that limited circumstance, the burden of proof will shift. You are the one to prove how you got the money, and it is not the business. So many, many important cases like that. And I know that the Supreme Court will also take this one and rule on it, and then thereby the rule of law will be entrenched in our hands. I get the point, though, that many people, are dissatisfied with what they regard as the excesses of anti-corruption agents, particularly the EFCC, recklessness and so on and so forth. As a matter of fact, again, while the chairman of the EFCC was being confirmed on the Senate floor, the president of the Senate looked at him and said, you see, there's a problem with how you people effect arrest. How do you go to people's places in the night and so on and so forth? But the anti-corruption agencies ought to be preserved, in spite of the fact that there could be challenges to its statutory existence. And those challenges will be sorted by the court of law at the end of the day. That is the arbiter in the circumstances.
Thank you, Jiti Ogunye. Thank you very much for joining us on the morning show.